I'm here again. Why can't he just work with me? And they already half do this and do that. I'm at the point where I feel like I already spoke with my benefits rep, UAW Legal Services, where I need to get me an attorney. That's something I have to come out of my pocket.
Hello.
Hi, Your Honor. How are you?
I'm good. All right. Where are we on her case?
Your Honor, I have a balance of $1,505.
Okay. She paid the $1,646 or whatever
On Monday, yes.
on Monday. Got it.
I don't understand why Robert, hopefully you're watching. Not you, Your Honor. First, let me state my name, Regina Agnew.
Thank you. I was going to ask, but you seem like you.
No, I'm really under a lot of
okay
distress. My asthma, it's just really been bad. I've been off work on a medical leave, and I explained it to him. I even explained that I was hospitalized, and I'm doing the best that I can.
Right.
I'm waiting on medical payments. And when I spoke with him on Monday, before making the payment, I said that you had stated in my Zoom last week that to see if I can work something out with with
right.
people at the office manager. Excuse me. So
just take you down. Okay.
So I said that to him. So because we're in September now, so September is due, obviously. And so he told me to, well, that's something that our attorney would do. I said, well, so then I told him that I'll come in the office because I had a follow-up appointment from being hospitalized with my primary doctor on Tuesday, but I didn't make it in the office to see him. I'm trying to get myself together because I miss making the money that I make, So I didn't make it into the office to have a conversation with him. And he's not so easy to have a conversation with because I can say to him, like you recall me a couple months ago in here, I said, I can pay, this and that amount. And he'll say things like, well, who else do you have to pay? That's none of his business, and I already feel like I told him he stresses me out. Communication is everything. And when I try to have a conversation with him, he likes to really kind of, well, the owner said that they're not going to renew your lease. Well, the owners act like I live in the Hamptons, with the old vintage closet doors and bulky paint on the wall. So since they bringing me to court, because I felt like he really didn't have to bring me to court because of course, yes, I need a roof over my head. I'm going to make the payments. I'm not a freeloader. I like nice things in life, but the way that apartment looked, no. That does not equate with what I like. And here it is. I'm here again. Why can't he just work with me? And they already half do this and do that. I'm at the point where I feel like I already spoke with my benefits rep, UAW Legal Services, where I need to get me an attorney. That's something I have to come out of my pocket. So I will. That's just something grandkids won't get for a little minute, It's all right. But the way he says to me, we pay $1,000 to take you to court. But don't take me to court.
All right.
I pay my court costs. And I'm saying all of this, Your Honor, to say the moral of it all is he is not easy to work with. And I need my reserve oxygen, seeing that he's not, being accepted and grateful for it.
So let me ask this. 1505, when do you think you can get that?
The 26th. I told him that I can make that payment.
Okay.
It could be paid by the 26th. And that's when he said, well, Doc, I don't know. It depends on what my attorney says.
Well, doesn't matter right now what they said because I'm adjourned. Can you get it paid early in the day?
On the 26th, yes.
Okay.
Yes.
So I'm going to adjourn this case out to the 26th because I'm going to have the final say. That'll be at 3 o'clock.
Thank you. I appreciate you.
Yeah.
I really do.
Thank you, man.
I really appreciate you being a fair judge. You're stern, but you're fair.
Stern?
Yes.
Is that a bad thing?
Oh, yeah, not at all.
Okay.
No.
Alan told me to be that way because I wasn't that way before.
You know, seeing that I have to be on your docket, I prefer to be on this docket than a criminal docket, you know?
That's probably true. All right, so get the balance paid by then. And
Okay.
if you have everything paid prior to that point and you're sure you got everything paid, you don't need to appear.
Okay, good, because I'm
Okay.
scheduled released to return to work in another week, so.
Okay, all right. So let's see if we can get that done, get it worked out, and then they'll just dismiss it if you get it.
Okay, thank you.
You have a
Thank
blessed
you.
weekend.
God bless you.
What a roller coaster of a hearing. This courtroom exchange between judge and defense attorney Edward Martell is a perfect example of how quickly tension can rise when credibility, procedure, and professional ethics collide. Let's unpack exactly what happened, why it mattered legally, and what lessons this moment leaves behind. The entire clash stems from a defense motion to have the presiding judge recuse himself, meaning to step aside, from continuing to hear the case. Martell's argument? That the judge had previously signed search warrants in the same matter, and therefore wasn't a neutral and detached magistrate, as required by law. He referenced People v. Burrell, a Michigan case, to support his position. His logic was that since the judge already found probable cause for the search, he had implicitly formed an opinion on key evidence and could not remain impartial in later proceedings. On paper, that sounds like a reasonable procedural concern. But here's where things went south. The judge immediately challenged the premise, questioning whether Martell even understood the distinction between search warrants and preliminary examinations. Signing a search warrant, the judge explained, doesn't involve hearing witness testimony or assessing credibility. It's purely a matter of whether the affidavit contains enough information to justify the search. It's a written, one-sided process. So when Martell implied that the judge had already heard witnesses, the judge called foul, and that's when the tone shifted, fast. The judge stopped the argument midstream, demanding clarity, and then accused the defense attorney of lying to the court. Not once, but repeatedly. He went back to the record, confirmed with staff, and discovered that Martell had cited a completely different case number belonging to a co-defendant handled by another judge. In other words, the very foundation of Martell's argument, that this judge had presided over the co-defendant's preliminary exam, was false. The courtroom energy turned electric. Martell, visibly shaken but trying to maintain composure, insisted that he made no false representations, and that any misstatement was simply a misunderstanding. But the judge wasn't buying it. He accused Martell not just of error, but of deliberate misrepresentation, saying, "Your argument started with a lie, and you continued with a lie." That's about as harsh as it gets in open court, especially from a judge known for precision and restraint. At this point, the judge did something very telling. He reasserted control over the record. He meticulously explained the actual content of the Burrell case, pointing out that Martell had cherry-picked a portion that supported his point, while ignoring the part that completely undermined it. The judge even read it aloud for the record to show that Burrell specifically allowed the same magistrate who issued an arrest or search warrant to later preside over preliminary hearings, as long as no witnesses were heard earlier. That directly undercut Martell's argument and exposed a major legal misstep. The prosecution then entered with a firm, confident response. Assistant Prosecutor Hughes cited multiple precedents, including People v. Cameron, 2013, and People v. Pitchford, 1971, both of which confirm that judges who authorize search warrants are not disqualified from later hearing-related cases. She also argued that Martell's motion seemed less about fairness and more about forum shopping. In other words, trying to get a different judge in hopes of a better outcome. That's a serious allegation in the legal community because it implies strategy over substance. The judge appeared to agree. He directly confronted Martell about possible forum shopping, saying, "You're continuing on with this frivolous argument." That's a strong signal that he saw the motion not as a genuine legal question, but as an attempt to delay or manipulate the court's process. Still, the judge remained procedurally correct. He didn't issue an immediate ruling, but instead ordered the defense to submit a written motion by a set date, giving both sides the chance to argue in full. That's how judicial fairness works. Even when tempers flare, due process still stands. So what's really going on beneath the surface here? From a legal standpoint, this case is a masterclass in the boundaries of judicial neutrality. The defense's motion was built on a misunderstanding, confusing procedural review with testimonial involvement. But the emotional core of this exchange reveals something deeper: how courtroom credibility can make or break a defense strategy. Once the judge believes you're playing fast and loose with words, every future argument faces an uphill climb. From a psychological angle, we're witnessing a real clash of pride and professionalism. The judge demanded precision. The attorney tried to maintain dignity. Both wanted control of the narrative. But in court, the record, not the rhetoric, wins every time. That's why judges rely so heavily on documentation and transcripts. Because memory can be subjective, but the record is permanent. This moment will likely live on as a cautionary example for attorneys. Always verify your procedural facts before making bold motions. A misplaced reference or misquoted case can instantly derail credibility, no matter how persuasive your tone. And for viewers, it's a reminder of how unpredictable real courtroom moments can be. They're not scripted dramas. They're live battles of logic, personality, and persuasion, all under the pressure of the law. So what do you think? Did the judge go too far in calling out the defense attorney for lying, or was he simply holding the line on courtroom integrity? Was this a moment of necessary discipline or professional overkill? Drop your thoughts below. We read every comment. And if you found this case as shocking and insightful as we did, make sure to hit that like button, share this video, and subscribe for more jaw-dropping courtroom breakdowns. Because here, every word, every motion, and every reaction tells a story about justice in real time.